Today on Bench Briefs, we're looking at a fascinating Supreme Court of Canada case that explores the balance between individual religious freedoms and public safety. Alberta v. Hutterian Brethren of Wilson Colony. This 2009 decision tackles how far the government can go in enforcing identification rules without infringing on religious beliefs. Here's the story. The Hutterian Brethren are a religious community in Alberta known for their traditional lifestyle and strong faith. One of their beliefs involves avoiding being photographed, which they see as conflicting with their religious principles. Because of this, members of the Wilson colony used driver's licenses that didn't display photographs, relying instead on licenses that only contained their names and other details. Alberta, concerned about the need for reliable identification to ensure road safety and prevent fraud, passed a law requiring all driver's licenses to include a photograph. This meant the Hutterian Brethren would have to get photo IDs, something they objected to on religious grounds. The community challenged the law, arguing that it infringed their freedom of religion, which is protected under Section 2A of the Canadian Charter of Rights and Freedoms. So the Supreme Court had two main questions to decide. First, did Alberta's law requiring photo driver's licenses violate the Hutterian Brethren's religious freedom? And second, if there was a violation, could the government justify it as a reasonable limit on that freedom under Section 1 of the Charter? Section 1 allows certain rights to be limited if the limits are reasonable and can be justified in a free and democratic society. The court recognized that the Hutterian Brethren's refusal to be photographed was sincerely based on their religious beliefs, and that the law did indeed infringe on their religious freedom. But that was only half the story. The bigger question was whether this infringement could be justified by the government's interest in ensuring reliable identification on driver's licenses. The court looked closely at why Alberta wanted photo IDs. They found that photographs on licenses help reduce fraud and protect public safety by making it easier for authorities to verify a person's identity. This is important not just for traffic safety, but also for preventing identity theft and other crimes. The court agreed that these objectives were pressing and substantial. Next, the court examined whether the law was proportionate to those objectives. They asked, did the law impair religious freedom as little as possible? Was the benefit to public safety significant enough to outweigh the harm to religious freedom? The court concluded that the mandatory photo requirement was a reasonable and necessary measure. The government had tried to accommodate the Hutterian Brethren, but allowing photo-less licenses would have undermined the integrity of the identification system. Ultimately, the Supreme Court upheld Alberta's law, ruling that while there was an infringement on religious freedom, it was justified under Section 1 of the Charter. This meant the government could require photographs on driver's licenses, even if it conflicted with religious beliefs. Why does this case matter? Alberta v. Hutterian Brethren of Wilson Colony highlights the delicate balancing act courts perform when individual rights collide with broader public interests. It shows that religious freedom is fundamental but not absolute. Governments can limit rights if they have a good reason and if the limits are carefully tailored. This case also illustrates how identity verification and security concerns can sometimes clash with personal beliefs, a tension that remains relevant today as we navigate issues like biometric IDs and privacy. The ruling confirms that public safety and fraud prevention are compelling reasons to impose certain requirements, even on religious communities. Thanks for listening to this episode of Bench Briefs. Be sure to join us next time when we dive into another important legal story shaping Canada's justice landscape. Until then, take care.